So, today, give me a second. Alright. What's up, folks? It's Naga Nick here. I'm in my robe because I literally just woke up. I have a cup of Joe. And today we're going to be getting into Title 4D of the Social Security Act, otherwise known as child support. Alright? Now, this is a controversial topic because the courts would have you believe that it's immoral, okay, to know this stuff. Honestly, because they use the words like, obligation to your child and all of these things, when that's not really what's going on here. What's what's going on is they're becoming a middleman, kind of like when you get married, the state actually marries the wife, and the the husband is kind of disconnected from both the wife and the state. So that's why in divorces, the state picks up all of these child support cases and all these paternities, and they pretty much target all men. So I'm going to go over this with you, all right? And you be the judge of what's really going on. I'm going to show you the facts. I'm going to take you step by step through the entire process, because when I went through it, oh my gosh, I just had this aching feeling in my stomach. Like, there is something wrong here. Like, something so wrong. I couldn't figure it out for the longest time. Like, why is the state and, the Child Support Enforcement Agency, all of this coming down to such a, like, interpersonal level? Like, we're talking about public officials and entities interfering in private affairs. That is so illegal that it's ridiculous. It is baffling, the things that I have found. The truth behind Child Support Enforcement Agency. The truth is stranger than fiction, folks. Sorry to say. This is oppression 101. This is private agendas and government affairs. But again, that's my own opinion. I don't want to sway you. I want you to be the judge. All right? So what we're going to do is I'm going to take you through the Child Support Enforcement Agency from the top to the bottom. All right? Now, I can't do every single state. Okay? So what you're going to have to do is you're going to have to take the initiative. All right? I'm going to show you where it starts in the Social Security Act. And then I'm going to go to Federal Revised Codes, and then the UCC, okay? And you're going to have to take it from there, okay? So you're going to have to go to your state, Constitution and your state revised statutes. Figure out the bridge between what I'm going to show you today and your state's codes, okay? Because once you know this stuff, you'll never have, be without a paddle in water again. All right? You'll never be lost again. And being able to present yourself in court is so much more powerful than having an attorney. Okay? So an attorney at law, you know what at means? It means near. They're not even near law. Not even. All right. An attorney in fact, you know what that means? It means rooted in law. Rooted. The only way you can perform law is to be doing it for yourself. If anybody else does it for you, they're near the law. They're not doing it for themselves. They're doing it for you. So they can't be really practicing law because you're the one who's supposed to do it for you. See what I'm saying? All right, let's get into this. So, here on the Social Security Act website, all right, Title 4D, Title 4, grants to states for aid and services to needy families with children and for child welfare services. Okay. So, the state gets a grant for these things. Now, let's say this particular state didn't have these things. Well, in order to create these things, they would have to establish a state and federal partnership. What is partnership, folks? A contract to provide child support services. What are child support services? Oppression. So the state's getting paid to oppress, coerce, and duress. Match requirements. Under Title 4D, the federal government reimburses states $2 for every $3 the state spends on an eligible program cost for providing child support services. Well, what? What? So, not only do they get 2/3 back from the federal government for doing it, but they get provisions, they get fees. Like, what? And you'll understand as I go along that this couldn't be more illegal. It can't get more illegal than this, okay? All right. States must have a single statewide agency that receives the federal funding and administers the program. So, one agency for the whole state, okay? And that agency divides up the smaller ones for the towns and cities. Okay, so where I live here in Kentucky, it's down in Lexington, I believe. Is it Lexington? It is, yeah, Lexington. Down in Lexington, folks. That's the one who does the contract with the federal government, okay? And all of the smaller cities, towns, and counties, they do business with the Lexington, okay? It's a private agency, by the way. It is not government. It's not. It's a private agency. So a private agency in public affairs, public government, controlling them to imprison you if you don't do what they say. Let's keep going. So, by the way, Title 4D was never enacted in positive law. So, it's not enforceable. It's a statute. It is not backed by the Constitution, the Bill of Rights. It has no jurisdiction over those things. So that's why every time you go in and you claim your constitutional federal rights and everything, they say, we're not here for that. No, because you're there for a private contract under guise of a courtroom. So here's laws and regulations underneath the U.S. Department of Health and Family and Human Services, which you can find down here. So, to be eligible for Title 4D reimbursement, self-help services, with the exception of allowable education and outreach costs, must be for paternity establishment and child support. This can include assistance with paternity acknowledgement forms, providing information to litigants about relevant court procedures. Relevant court procedures. Now, how is that relevant court procedures when it says over here? All right, so look. This is Code of Federal Regulation 45 CFR Statute 30233, services to individuals not receiving Title 4A assistance. Not receiving. So anybody else receiving any kind of assistance besides Title 4A. Okay? Application fee. Beginning October 1st, 1985, the state plan must provide that an application fee will be charged for each individual who applies for services under this section. Under this paragraph, the state shall collect the application fee from individuals applying for 4D services or pay the application fee out of state funds. What? What? So the state makes money for every application fee. Okay? That is accepting a bribe. That's what it is. Bottom line. It's incentive to put people in child support, which ultimately puts them in jail. So if the state makes money and every police officer, every judge, every attorney or prosecutor or lawyer who touches your case makes money off the case, what does that tell you? What does that tell you? Don't worry. Well, I'm going to show you. Check this out. The state may recover the application fee from the non-custodial parent who owes a support obligation to a non-4A family. Okay, so a non-4A. Okay, so that's any other title in the Social Security Act, on whose behalf the Title 4D agency is providing services, and repay it to the application. to the application or itself. Now, what they're saying is if the mother decides to go after the father for child support, they don't only try to make the father the liable party, the liable person, the obligor, because the state would have to be the obligor. Because remember what I said earlier, you know, that triangle where they were like, with the, when you get married, the state actually marries your wife, not you. You know, and then when you get divorced, the state backs the woman so they can go after you for child support. Because Big Daddy protects mommy, right? Well, this is why, folks. This is why. Because they want the money from you. They want to make you a slave. They want to make you into their battery. All right. State funds used to pay an application fee are not program expenditures under the state plan, but are program income under of this chapter. Let's see what that is. Treatment of program income. The Title 4D agency must exclude from its quarterly expenditure claims an amount equal to all fees which are collected during the quarter under the Title 4D state plan and all interest and other income earned during the quarter resulting from services provided under the 4D state plan. So now here we have interest. Where did interest come from? Where did it come from? This is insane. A flat dollar amount not to exceed $25 or such higher or lower amount as the Secretary may determine to be appropriate for the fiscal year to reflect increases or decreases in administrative costs, or an amount based on a fee schedule not to exceed the flat dollar amount specified in paragraph C2 4A of this section. The fee schedule must be based on the applicant's income. That's how they do it. They're not bookkeepers. They're not accountants. But yet, they determine how much child support you owe. That doesn't make any sense to me. No. The state may allow the jurisdiction that collects support for the state under this part to retain any application fee collected under this section. So, the state may allow jurisdiction. So, jurisdiction is the area that collects support for it under this section. So they get to retain whatever fees of that jurisdiction. All right. In an interstate case, that means two states, different countries, doesn't matter. The application fee is charged by the state where the individual applies for the services under this section. So if you're like in two different counties, the main county where the applicants, the first application was submitted. All right. Recovery of costs. The state may elect in its state plan to recover any costs incurring in excess of any fees collected to cover administrative costs under Title 4D state plan. A state which elects to recover costs shall collect on a case-by-case basis either access actual or standardized costs. So I'm not even going to pretend what this means. But from what I gather is when I think it has to do with rearage. We're going to go over that later. I'm going to take a double dive in that. From the individual who owes a support obligation to a non-4A family. So this is all just coercive language, pretty much. All right. What it's really saying is a Title 4D applicant who owes. All right. And all of this is voluntary. Okay. Like, you have to understand it is voluntary to sign that contract. They can't force anything on you. And if you know what you're doing, they can't. They just can't. They try to get me to sign this contract so many times. All right? To the point to where they even literally put me in a cell until I signed. Okay? Now, I have fought that so much. All right? I have fought that so long. How is that not duress? How is it not? But ever since, I haven't signed nothing. On whose behalf the Title 4D agency is providing services under this section, or from the individual who is receiving Title 4D services under paragraph A1I or 3 of this section, either directly or from the support collected on behalf of the individual, but not only if the state has in effect a procedure for informing all individuals authorized within the state to establish an obligation for support that the state will recover costs from the individual receiving Title 4D services under paragraphs A, 1I, and 3 of this section. Now, this is where you get into the nitty-gritty details, okay? So, every state-by-state procedure is different, all right? But it's all outlined here, okay? So, it starts at the Social Security Act, all right? Part B, Part C, Title 4, Part D, Child Support and Establishment of Paternity, Appropriation Duties, Federal Partner Locator Services, or Federal Parent Locator Services, State Directory of New Hires, State Plan for Children and Spousal Support. Now, mind you, understanding that both Title 40 of the Social Security Act and the CFR, Code of Federal Regulation, are interconnected, okay? It's like a gridlock, all right? On top of the UCC, okay? First the UCC, then it's the 4D service, 4D, Act, and the Code of Federal Regulation. Why is that? Because it has to do with a contract. So anything has to do with contractual basis, it goes under UCC. Okay, so first, you need to understand the UCC, and what it has to do with child support. Okay? We're going to get into that. Look, I'm going to show you. It's going to take some time. And I'm prepared to do all that. All right? I'm going to show you exactly how to deal with these people, how to deal with the child support agency, how to deal with these regulations, these codes, and these procedures. Because all they're doing in court and family court, it's kangaroo court. It is literally a circus, okay? There is no family court, okay? How can there be a family court when court is about public affairs, public contracts, not private? When you have a private matter, what jurisdiction is that? Common law jurisdiction, not maritime law jurisdiction. What is family? Family is common law jurisdiction. So what they've done here is they've taken your allegiance, all right, your creature of law name, your sole proprietorship name with your social security number, and they've made it into where you have to not just support, but you have to pay them to take care of your family. What? Are you kidding me? Like, I can't even have a kid now because you guys are taxing me on having kids. And by God, if this woman gets emotional and you guys fill her head with obscene, just disgustingly weaponizing her against me, and now I can't even, what? Now I have all these codes and regulations I have to follow just to be a part of my kid's life. What? I'm pretty sure that it does say in the Supreme Court that the household and families are sacred and are under common law, and that the state should not interfere. I can guarantee it, actually. You see, but people do not know their rights. I'll have that case for you guys next time. But I want to get into some more nitty gritty over here, so let's see what else I can come up with for you. Alright. The HHS, which is the Health and Human Services, clarifies that funds can be used for services to increase pro se access to adjudicative and alternative dispute resolution processes in 4D cases related to providing child support services. Do they do that? No. Why? Because they don't really want you to know what's going on with these contracts. They don't want you to know. They don't want you to know as soon as you sign, they send that bad boy down to Lexington, and Lexington sends it off to the federal discount window to get some money for it. And then guess what happens? Not only do they collect the funds, the entire funds of your entire contract, which this one was $68,000, something like that. So they collected all the funds already. They could have distributed them straight to the mother, but you know what they did instead? Do you know what they did instead? They kept it and made the father liable. After the father had signed for the security, created the security out of thin air, poof. $68,000, poof. Only because the father signed. Then that got sent down to wherever your statewide thing is. All right, statewide child support enforcement agency is. And then, voila, money out of thin air from FedNow or FedWire. Okay? Now, instead of sending it to the mother, they kept it, made the father the liable party, enforced it on him, threw him in jail, yada, 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 so on and so forth. He has to pay now for the rest of freaking life because the Child Support Enforcement Agency is a private agency. They're giving services not to the father, but to a third party. Themselves, the federal government, and the mother only gets the benefits from the father, not from the government, not from this enforcement agency, besides locating the father, which is outlined here, enforcing child support and paternity, which is outlined here, and representation on the mother's behalf under a false name, acting as the state when they are not the state. They're not the state at all. They are the Child Support Enforcement Agency, not the Commonwealth of Kentucky, not the state of Ohio, not the state of Indiana. No. The state can't be harmed. There is no crime there. You have no accuser of harm done, no witnesses, no evidence, and you have a false contract that was under duress because you threatened him about jail, taking away his freedoms. That is evil, disgusting. That is crazy. So, parent locator services. Here are the availability rate for the federal financial participation. Federal financial participation at the application matchmaking rate is available for necessary and reasonable expenditures for child support and services and activities to carry out the state Title 4D plan. Parent locator services, paternity and support services, services and activities for which federal financial participation, remember, they're participating in a federal grant program. In order to get the grants, which means more money for the agency, the state built the Child Support Enforcement Agency and placed it somewhere, the capital of your state. And in order to get those grants, the state has to follow these rules. Now, not only do you want to know these rules, but you want to make sure you let them know, like, hey, if I catch you stepping outside of these rules, I'm going to tell. Or I'm going to take you to a federal court. Because you gotta understand, these people are taking your freedoms. They're destroying your families. They're turning kids and parents against each other. All in the name of the mighty dollar. This is Mind Control 101. Now, you have two choices here. You can either let these people keep you in fear forever on having children or ever falling in love with anybody, or you can tell them I know your daddy. That's so funny. So, you can use the big bad law against them. Alright? Securing compliance with the requirements of the state plan and operations under any agreements. Securing compliance. Compliance. This pretty much means establishing control. Look, cooperation with courts and law enforcement officials and Indian tribes or Indian tribal organizations pursuant to of this chapter, section 302.34. Let's look at this. Cooperative agreements. Now, this is the agreements from the agency in the capital to all of the counties and all of the cities. All right, you ready for this? The state plan shall provide that the state will enter into agreements which are reflected in the record for cooperative agreements under 303.107 of this chapter with appropriate courts. All right, let's put this in another tab too, just to be safe. Law enforcement officials, such as district attorneys, attorney generals, and similar public attorneys and prosecutors, correction officials, Indian tribes, and tribunal organizations, such arrangements may be entered into with a single official covering more than one court official or agency. So this is saying, if it's your county clerk who's doing business with the Child Support Enforcement Agency, or the person who owns the court or the county, or because it's all a business, it's a incorporation. Okay, so your mayor or whoever, dude, it can be with such arrangements may be entered into with a single official. So they only need one official to establish child support in every county, every city. If the single official has the legal authority to enter into arrangements on behalf of the courts, officials, or agencies. So they go through the person with the authority. See what I'm saying? Such arrangements shall contain provisions You know what provisions means? They get money every time. Every time there's a case. Do you see? Do you see? You know, lawyers are not allowed to contract with government. No, a contractual lawyer, they're supposed to be doing their due diligence on your behalf. For you. But when you get a public defender, they're getting paid to put you in jail. They're getting paid to create this child support case on you. I went over my documents, like, it is insane. It is outlandish what they're doing. They're trapping you. They're trapping all of us. You have a child, you're not safe. Such arrangements shall contain provisions for providing courts and law enforcement officials with pertinent information needed in locating non-custodial parents. Establishing paternity and securing support. To the extent that such information is relevant to the duties to be performed pursuant to the arrangement, they shall also provide for assistance to the Title IV agency in carrying out the program, and may relate to any other matters of common concern. Under matters of common concern, such arrangements may include provisions for the investigation and prosecution of fraud directly related to paternity and child and spousal support, and provisions to reimburse courts and law enforcement officials for their assistance. They're literally telling you right here, hey, if anybody comes around saying we're committing fraud, you got to tell us. They're literally saying it. Do you not see? Do you not see it? They're literally telling you right to your face, we are committing fraud. This is fraud. We are entrapping you. We are making you sign contracts under duress. We are using coercive language to trick you. You think obligation means this. You think child support means this, but it does not. And we're not going to tell you that. Wait till I show you definitions. This is not the definition section. I'm showing you the rough outline of what they do. This is insane. Requirements for cooperative agreements. The state must ensure that all cooperative agreements, A, contain a clear description of specific duties, functions, responsibilities of each party. A. B, specify clear and definite standards of performance which meet federal requirements. C, specify that the parties will comply with the Title IV of the Act, implementing federal regulations and any other applicable federal regulations and requirements. Number 4 is going to be useful, by the way. C is going to be useful. D, specify the financial agreements, including budget estimates, covered expenditures, methods, and determining costs, procedures for billing the Title IV agency, and any relevant federal and state reimbursement requirements and limitations. Because remember, for every $3 they spend, they get $2 back. Specify the kind of records that must be maintained and the appropriate federal, state, and local reporting and safeguarding requirements. Hey, if anybody says we're committing fraud over here, you have to tell us. Specify the dates on which the arrangements begins and ends, any conditions for revision or renewal, and the circumstances under which arrangements may be terminated. So usually, when you go into court, they can only enforce child support for like 2 years, right? And then they'll call you back in and make you sign over again to continuously applying that pressure on you. Okay? So after that 2 years, they'll have to come back out and get you, kind of stuff. All right? Or make you go to a court date or do these things, okay? So that they can renew those conditions, those continual conditions, okay? Because contracts can't last forever. There has to be a time limit. But they don't have a time limit on these contracts, do they? I see no time limit for these contracts. This is sad. This is sad. So, 1, 2, fun. Annual collection fees. For each federal fiscal year after the first $550 money sign of support is collected and dispersed to the family, the fee must be collected by one or more of the following methods. Retained by the state from support collected in cases subject to the fee in accordance with distribution requirements in, we're going to open that, of this part, except that no cost will be assessed for such services against a foreign obligee in an international case receiving 4D services pursuant to the section. Why is this section like that? That's weird. You can't really... Let's see what's going on here. So, 3251 of this part, distribution requirements. Hold on, which one was it? Okay, it's 5. Okay. A5. Boom. Except as provided in paragraph A52, A state must pay to a family that has never received assistance under a program funded or approved under the Title 4A or foster care under Title 4E of the Act, and to an individual who is not required to cooperate with the Title 4D program as a condition of food stamp eligibility as defined at of the Title 7, the portion of the amount collected that remains after withholding any annual $35 fee that the state imposes under this section. So they take a fee. So that fee's right here. It's under E. See? Annual collection fee. Alright, and as we go on and on, the more we dive into this, the more you'll see this stuff. It's a house of cards. It's about time we flick it over. But that's all I got for you today. Alright. You know, code is rough. You know, it's long and it's enduring, but you know, if you're a junkie like me and you just wanna learn stuff, you wanna see how things work, you wanna see what fabrics are holding up what, you wanna see into the realms, stop back by. I'm Navigator Nick. I'll see you guys later. And let's go out there. Let's get these people. We'll be like, hey, we know what you're doing. Stand up for yourself. Represent yourself. Hold your head high. God's with you.